to adjust, change, or modify the management of the domain name unique identifiers. And so in that sense, we've had some experience, and we have, of course, needed to work across the internet ecosystem with our colleagues at the IETF, for example. Mark was talking to us about how they make their standards. Obviously, the Internet Society, the regional internet registries, and many others have formed the internet ecosystem. Again, as part of this distributed network, following in that tradition, the distributed governance network that we all prefer to follow. Needless to say, this has been going on for some years. We celebrated the 15th year of ICANN, and to that extent, that is an important milestone. But like any other milestone, we have to figure out and address what's next and how best to do that. Because in our approach to multi-stakeholder model that we think is working, we all think it can be improved. And we can expand that as we begin to expand the top-level domains beyond the few that we had, .com and .org. And that is progressing now to the fact that we now have over 300 new top-level domains. In addition, we have internationalized domain names so that one does not have to use Latin script or English language. You can do it in your own native script, or Cyrillic, or Chinese, or whatever. Again, looking at that next billion people users, how to have them engaged, and thus the scalability of our processes for policy development to also engage those people in their languages and in the system that we're doing for the management of the names and the numbers. So I'm very happy that this group of academic experts and research centers are looking at the next steps. We were very pleased with the Net Mundial organized by Brazil in a true multi-stakeholder process, but I must say that we also were playing a part, and others were too. There were 1,400 stakeholders from 97 countries, and to broaden the participation, there were 30 remote participation hubs around the world so that people who could not travel to Sao Paulo, Brazil, could participate. And this, of course, is what we do at our ICANN meetings as well. We have these remote participation elements for us. In the 2 days, there were 188 written submissions, significant discussion on internet governance going forward. The end result was the 7 principles that we've heard about, as well as a possible way forward by the internet community who've come together. And these were academics and technical groups, civil society, private sector, all looking to keep the internet open and barrier-free. And so to that extent, this next step is very important as to what the multi-stakeholder approach should be in the future and how this distributed governance system for it can be improved. And there are some case studies such as IETF and ICANN and how this has been working, and working somewhat, I think, well for the last 15 years or so. So with that, I will stop and say we are supportive of the Net Mundial statements and principles. There was a recent report by the high-level panel on further recommendations, some ideas of specific concrete results. Again, we welcome those ideas, and we think that the best way to find a solution is to engage this bottom-up consensus approach because that's how the stakeholders understand, are involved, and can support decisions going forward, as opposed to a top-down model that might say, here it is, take it or leave it, and that is the only thing that's left. So I thank you very much for this participation, for time to come.
Thank you, Sam. Gonenc, please.
Thank you. Hi. I think the most important thing to note beginning the thought process on multi-stakeholder approaches is why is this so necessary and so significant in the internet world, and why is this a baby of the internet world first and foremost? And the answer is really simple. Because when you're regulating the markets for goods or services, what you're doing is basically having a local impact still on a totality of people, but local in the sense that one jurisdiction can differ from another jurisdiction, and it does not necessarily have direct impact on what is happening in the other jurisdiction and on the welfare of another citizen of another jurisdiction. So if you are born in Cuba, it is anticipated that you're going to have a different life than someone born in India, and a different life as compared to someone born in Virginia, United States. That's to be expected. It's the way goods and services are regulated in those countries, and the impact of what is being done outside of your jurisdiction is really an impact that is indirect. Whereas when you're looking at the governance of the internet, you're really, truly, honestly looking at a product that is owned by all citizens of the world. And to the extent this is a playground of everyone, and to the extent all governments are able to take a stab at fundamental principles of this, there are going to be huge inefficiencies. So first of all, you need to therefore come to terms with the idea that as a product, ideas are really different than services or goods. If you're in the ballgame of regulating ideas, then you are in very delicate ground. Hence the discussion on whether we should do it top-down or bottom-up. What is perceived by the citizens of that state, and certain criminal law principles may be rejected by the rest of the world, but the rest of the world would then try to escalate that society to the level of their understanding of human rights. Whereas in the criminal law field or in any other field that you may choose as an example, you're not looking at multi-stakeholder type attitude, because governments do have the ability whether this was a government going into some form of an enforcement on the internet that may or may not be ideal. When the law is changing now, the 5651 is changing in Turkey, see if this is in the best interests of freedom of speech and the right to know the ideas of the or whether there are certain other complicated rules in the legislation. The only way to know is to be able to discuss it. And unfortunately, that discussion cannot happen in certain governmental This is true with a lot of law, but when you're talking about products that is ultimately designed to have ideas, it becomes all the more germane to the analysis that you have to have a multi-stakeholder approach, hence a bottom-up type of approach. The typical criticism against bottom-up approaches is that there are very rare decisions. This is true. I've been a student of Jonathan Dufresne at Harvard Law School in 2001. Ever since I've been doing internet law, and I have been teaching internet law for the last 8 years in Turkey as well. And one thing I can say is that to the extent you are subscribing to a multi-stakeholder type of environment, and not in an environment where there are, decisions as to what is right, what is wrong, what can be done, what cannot be done. But this is not the fault or missing prong of multi-stakeholder approach. It is because you have to take these steps if you have come to terms with the in the internet world. To the extent you're taking giant leaps of faith, as governments tend to do, and then test the results of that leap of faith, you are going to find a lot of inefficiencies and a lot of ill, perverse results that are coming out of this that are very difficult to fix afterwards. Today, we're trying to shift to a regime of an access provider's union in Turkey. I am deeply involved in all concepts of internet law in Turkey, and I am yet to have an idea of what exactly this access providers union is.
The law, and they don't want that responsibility either. It's not a natural result of a desire. It's not self-control. It's not auto-control. It doesn't look like anything else elsewhere in the world. So why is this happening? Because there is still the governmental will to regulate, but the government wants to distance itself from what is being done. So there you go with the Access Providers Union. The reason why I'm using this particular example is because I am trying to underline that you cannot, even if you wanted to, you cannot mimic multi-stakeholder approach. So you cannot bring together only one segment of the internet world and tell them that now you are acting as a whole and it's not truly governmental. That is what is happening, because a multi-stakeholder approach can only be done the way ICANN was being formed 15 years ago, and drip by drip and with a lot of intrinsic dynamic coming together. So we have to work toward that end, and we should distance ourselves as much as possible from approaches of black and white sentences. My disclaimer at the last: I am representing certain companies in Turkey. I am an attorney beside being an academician, and I have not been speaking on behalf of any client of my law firm. I have been speaking in an academic capacity and purely in an academic capacity. Thank you.
Thank you. Extremely challenging views. Mehmet, please, you.
Thank you so much. Indeed, thanks. Professor Wolfgang mentioned about ecosystems. Indeed, apart from the ecosystem of multi-stakeholder governance or internet governance, there are also other ecosystems that we can learn from, and also indeed the internet governance has also inspired from. Today I will try to provide an overview of the legal foundations of internet governance in Turkey under Turkish law, and also I will try to question the normative value of internet governance in Turkey, but I will benefit from environmental law while I'm trying to identify the normative value conferred to internet governance. When it comes to the multi-stakeholder governance, it's widely accepted that it's a dynamic concept there is an evolution, and the changing circumstances of the world community requires a dynamic interpretation of this concept which is shaped by changing circumstances of social, economic, and technical context. And also the participation into the decision-making process of internet is also quite complex and contested issue. There are some starting points. There are some blueprint approaches that has been put forward by different stakeholders, by different organizations. But in the most of the cases, these definitions and these approaches are shaped according to local contexts, depending prevailing political, historical, cultural, and technical circumstances. In that regard, multi-stakeholder governance embodies certain contextual uncertainty, but I consider this uncertainty not a weakness. Indeed, it provides a flexible interpretation of the concept according to changing contexts. Although there are different interpretations, there are discussions about multi-stakeholder internet governance, the common principle within this concept is right to participation to the decision-making process. In order to understand the legal status of these under Turkish law, we should, I had the chance to look through to different regulations, legislations, and try to find out whether the right to participation is a normative value or is it just a political matter which is conferred by the government. It's just something that totally depends upon the discretion of the government. Under the Turkish internet law or similar telecommunications law, there isn't such a requirement, but indeed such a requirement exists under the environmental law. The reason why I will provide this provision or principle of environmental law, indeed when internet governance was being discussed, doctrined, different approaches emerged, and in that sense, mostly the discussions surrounding sustainable development law has inspired these discussions, and so that the environmental governance has inspired internet governance. When we look to the Turkish environmental law, it was also inspired from these developments, and there is a provision under Article 3 of the environmental law, which states that the right of participation in the establishment of environmental policies is essential. The ministry and the local administrations are obliged to establish the conditions of participations which will make possible for the chambers of commerce, associations, non-governmental organizations, and the citizens to exercise this right of theirs. When we look at this provision, first there is a mandatory requirement. In other words, this distinguish the right of participation from a political matter. It's a normative norm, which means that we have a legal expectation to implement this provision. On the other hand, when we look at the Turkish internet law, in particularly the Act number 5651 or other laws which have impact on the regulation of the telecommunication sector or internet actors, we don't see such a requirement of participation. In other words, as Leyla mentioned, there exists a body in Turkey entitled Internet Improvement Board. It has conducted certain stakeholder meetings. Indeed, they were discretionary activities that were, how can I conceptualize it? They were not something that requirement of the law. Because when we look at the law that regulates this body, the law says that or regulates this body as a consultant to the ministry. Although there exist different stakeholders under this board, it's not mandatory to ask to this board for any amendments to the law. which happened to the recent change to the Act number 5651. So whenever any law related to internet or any regulation related to internet is being codified or it is in a draft stage, there isn't a mandatory requirement of conducting an impact assessment. This is the weakness of the Turkish law. And my thesis is that there is a deep correlation between environmental law and internet law, particularly when it comes to the right to participation. If the democratic culture is mature in a country, we see that the right to participation to the environmental issues is being implemented very well and very profoundly. On the other hand, if there isn't such a culture of participation within the society, it's really hard also to implement these internet governance rules as well. So there are also different examples of this, and also as I mentioned, when the internet governance theories emerged at international level, the very first places they looked to inspire from were the discussions surrounding sustainable development law and environmental governance. In that regard, I would like just to copy the provision under the environmental law and change the provision under this law, the term of environment to internet, and I would like to read this, and this is my proposal. If there will be any kind of provision that should be incorporated to the Act number 5651, it should be like this, and I think that this will also eliminate any further concerns. So it will be a legitimate expectation. As Mr. Gonenc talked about this, whenever there is a regulation, a draft law that will that will affect the interests of the companies, the clients that he presents, he should have a saying. But this shouldn't be regulated under like a political contribution or political gift. It should be a legal expectation. In that regard, I would like to read the provision replacing internet instead of environment. So my proposal is that there should be such a provision saying that the right of participation in the establishment of internet policies is essential. The ministry and the local administrations are obliged to establish the conditions of participations which will make possible for the chambers of commerce, associations, non-governmental organizations, and the citizens to exercise this right of theirs. Thank you so much.
Yeah, thank you. Really fascinating and very concrete thing to add to the debate. Thanks so much. So, last but not least,
thank you so much, Wolfgang, and I'm proud of my students. He's my students from the graduate level, so it is honor to be here, and I would like to have a chance to give a speech to you. And we are in between the friends, and we have a very distinguished speakers and very distinguished experts in this meeting room. So, I'm representing TÜBİSAT, Turkish Businessmen Industrialmen Association, which is the largest NGO in the information and communication technology sector, and that's nearly represent the 95% of the whole information and communication technology sector. So I'm giving my speech on behalf of TÜBİSAT today. So I have extract some items from the Net Mundial statement. So I would like to match the items from the TÜBİSAT works that have already been done before. And I would like to give us some information about the political climate in that items in Turkey, and also how the NGOs are making contributions to get the results of these items that has been listed in the Net Mundial statement. So one of the issues is that standardization. So the standardization as you know, that the classical meaning of standardization is to set out the standardization which is set by the standardization authority, and also get the certification and showing this certification to the related parties to meet this standardization. So, but the modern understanding of the standardization would be completely different. Especially the last 10 years, when we are looking at the standardization approach, especially in the internet sector, the self-declaration is a useful method to be applied for disseminating and also employing the standards in the information and communication technology sector. For example, the European Telecommunication and Standardization Authority, ETSI, and also the CWA standardization are also always applying the same methodology to disseminate the sectoral standard. For example, in the internet sector, Internet Engineering Task Force are doing these things very brightly. So when we are looking at our efforts at TÜBİSAT site, we are closely cooperating with the Information Communication Technology Authority, which I am seeing my friends from there. We are closely working with them because they are also have an authority to disseminate these standards and to apply these standards over the information and communication technology players in Turkey. So we are trying to position TÜBİSAT as a sector player and to generate the standard for making workshops with the Information and Communication Technology Authority, and to set out these standards and to disseminate these standards, and also encourage the sector players to fulfill this standard which was published, which will be published by the help of the Information and Communication Technology Authority and the TÜBİSAT members. So it's the kind of the attempts we have not realized yet, but we have started working with Information and Communication Technology Authority on that regard. So we are on the way. So the realization will be happened very soon. But this is the good example in Turkish environment for introducing the voluntary-based standard regime in Turkey. And the privacy issue, of course, privacy is one of the key elements from the Net Mundial statement. When we are looking at the Turkish regulatory environment, we have no data protection regulation. So this issue was discussed the yesterday meeting, very detailed manner. But impact of this privacy regulation, lack of this privacy regulation into the information and communication technology sector, and Turkish information and communication technology sector has been booming, especially the last 10 years. So we are right now in the second place in the Middle East and Africa region. The first market in the Middle East Africa region is South Africa. Turkey is the second place. So all the multinational players, considerable number of the multinational players made an investment and to open their offices and also move their operation in Turkey. And this is going to be the attractive environment for making an investment in Turkey for the multinational players. But if you would like to render your services to be based in Turkey, the lack of the privacy regulation is the biggest barrier for rendering your services, especially to the European Union countries. Because according to European Union regulation, Turkey deemed as an unsecure country for the international data flows. So it is very hard to centralize these services and to render these services based on in Turkey, lack of the privacy regulation. So what TÜBİSAT has been done for making awareness at the government organization for the privacy regulation, we made several visits to government officials and the ministers, and to make a direct communication with them, and also European delegation. We also made a clear communication with them, and also encourage them to give these messages to the related policymakers in Turkey to fasten up the enactment process of the data protection regulation in Turkey. So this is the biggest barrier, because if we would like to do something, because we know that, especially the European Union, right now the current economy is defined as a data-driven economy. So data-driven economy means that if you do not process the data, you cannot do anything. So if your economy would like to run into the data-driven economy, the first regulation should be taken place is data protection regulation. So each and every year, not to enact this regulation, we are losing our ways and our competitive advantages across the global market. So this is the crucial step to enact this regulation. So in the NGO WISES basis and the TÜBİSAT basis, we are also giving our ideas and also opinions to related government authorities. One of the very, very important items to be stated out in the Net Mundial statement is democratization standard. And fortunate to say that we are far away to reach out to this standard. So Gonenc explained very briefly and also states that very good points. And you know that it is a quite common practice, unfortunately, in Turkey to block access to websites. So when we are looking at the other democratization, democratic states in all around the world, it is not these kind of applications are happened. So we have to criticize ourselves and we have to reach out to certain democratization standards for meeting the issues that has already been stated in Net Mundial. And the other issue is that the multinational roles. It is very important, I think, because multinationals, as Gonenc mentioned, that we are using, we all are the internet community. So we are using the products of the multinational companies. So it's you know, that's a very important the comments and a very important statement in the information and communication technology law, and the extraction from the lesson book. Who writes the code? And so this, you know, that this was an inventory and an explanatory speech, and also Lessing made this speech in front of the congressman in the US. So it is also true argument that the code writes by the multinational companies. So the influence of the multinational companies is very crucial to create a global internet governance approach. At the end of the day, when we are looking at all the international organizations, in the first place, they will they are making a contact with these multinational companies to understand their business dynamics, and after that they set out some policies and make a negotiation with them. So when we are looking at our local dynamics, so the TÜBİSAT is an umbrella organization, so all the multinational companies are membered. So we are also giving our efforts to have a better understanding of the multinational companies in Turkish regulatory environment and the cultural environment in that regard. Unfortunately, internet companies has not been member yet in TÜBİSAT because most of them have now offices in Turkey. But the multinational companies who have already have an office in Turkey are the member of TÜBİSAT. And academic network is also always important, so we appreciate Leyla Hoca to bring this opportunity to meet with you, with this distinguished academics. And also we are trying to gather all the information that is extracted by you and to disseminate this information into the sectoral players. So most of them, their main role are focusing on to business, but most of them they miss the global dynamics of the internet governance and the global dynamics of the internet economy. So your studies and your works would be very valuable to give them the intellectual level understanding of what the world is going on. So we are also putting this kind of academic works and to disseminate this academic work into the TÜBİSAT network and to reach out the players to this academic network. So we are closely working with, we are closely watching the developments at the networks of centers. So whenever the new articles has been published, so we are also disseminating this article into this network. And follow the international development. International development is very crucial. TÜBİSAT is the member of the Digital Europe. Digital Europe is, you know, that one of the largest NGO at European Union sites. They are representing nearly the 3 trillion euros economy, and they are making a deal with the European Commission directly. TÜBİSAT is the only one organization from here as an NGO to be member at the Digital Europe. So we are closely cooperating with them to get their understanding and also put our also thoughts and opinion, which we would like to give a direct access to European Commission for shaping up the related policies at the European Union site. And government relation, yeah, the government relation is very important. TÜBİSAT is one of the prestigious organizations in here. We have a very close cooperation with the government. So we are using this trustworthy environment for making connections and also disseminate our ideas and opinions to directly the government. So thank you so much.
Thanks very much. We are already run out of time, but maybe we should allocate at least 10 minutes to questions and remarks from the audience, if it's possible. I'll just take a sharp look at the timekeepers. Any questions or remarks, please? I think we have a microphone here somewhere. And please be kind enough to introduce you briefly. And is there? It's coming. Since we talked about participation a lot, I think it's fair to give the chance to do that. Thank you so much.
Hi.
Yeah, it's working.
It's working.
Yeah.
Do you hear me?
Yeah.
Okay. My question is that is it realistic to expect governments to have two different lawmaking avenues? One is for internet-related issues, the other for other issues. I mean, are they going to say that is it about vacuum cleaners? So let's send this regulation to the parliament. Oh, it's about internet. Okay, let's make it through a multi-stakeholder ways. Is it realistic? I mean, by the way, I work for the government.
Fair point. I give it to the panelists who wants to. Yeah, sure, of course.
Contribute to that. Indeed, there exist impact assessment procedures which are mandatory all around the world, and also under the Turkish law as well since 2005. The regulation entitled the preparation of the draft laws also says that there should be an impact assessment procedure. And when it comes to the impact assessment procedure, they also embodies a social aspect. There should be some kind of a dialogue also, or there should be empirical analysis, interviews in certain circumstances. So if we look through the impact assessment procedure, instead of dividing these to internet policies and other policies, if we can say that impact assessment procedures are implemented very well, there will be not such a concern, but it's again depends on the culture, tradition. Since 2005, we have been looking through different laws and trying to find out whether are there any impact assessment. Just talking for Turkey, no. So this is something we are missing out. On the other hand, whenever I'm looking for any document coming from the European Union or any other member states, if there is a draft law, if there is a law, we can see apart from the recitals, apart from the preamble, we are able to see impact assessment reports and why it has driven to make such a regulation. What is the impetus behind such a reform? But again, this is regulated under the impact assessment procedures, and this is also evolving when it comes to the European Union. Now they have this sustainability impact assessment, adding another layer of complication, another layer of consideration. But in Turkey, we are still lacking implementing the basic impact assessment procedures. Thank you.
I think the response to your question highly depends on which government and which society we're talking about. In an ideal way of governance, the first and foremost objective of the government is to maximize social welfare. And to the extent a government would realize that interferences in the ideas market is minimizing social welfare, and to the extent ideas flow freely, the total welfare function is supported, the governments will start to ask themselves the following question. So how on earth am I going to govern this without playing a very dangerous game with the welfare of the society? Because I am lagging behind. My children, my nation's children, are not as well-rounded as some other nation's children. That is a problem for me as a government, if I am defining this as a problem for me as a government. And then the next step is going to be, well, you know what, the governance will have to come intrinsically. It's going to have to be endogenous, if you will. It's going to be very difficult to give exogenous stimuli into this, and it will have to be endogenous. But I would say that for that, of course, the multi-stakeholder approach will have to mature, and the multi-stakeholder approach will have to have some beef and bone in it, so that when you are looking at the multi-stakeholder approach, you are really looking at a capability of bringing something forward. If it's just a nice idea, if it's just a discussion point, of course, any vacuum will be filled by the governments, and that's why I do agree with you that at a point in time when you're taking a snapshot of a given government, and I do have a vague idea as to which government you have in mind, then of course, to the extent there's that vacuum, to the extent there are no NGOs, and to the extent almost half of the stakeholders of internet are already in this room, then yes, the government will have to play a role, is what they feel. So that's what will need to be changed. I hope I'm not doing that.
It's the NSA is everywhere. Yeah, sure, of course. Please, Maria.
Just a quick comment. In Brazil, we have developed a structure that is called the Brazilian Internet Steering Committee. It's a multi-stakeholder body composed, half of the composition is members from the government, and the other half it's distributed between civil society, technical community, private sector. Each sector elects their representatives, and what we are trying to do is little by little, every policy that is related to the internet, this body should be consulted in the process of policy development and regulatory development for the internet. So we just did that with network neutrality. In Marco Civil, there is a general principle, a general provision regarding network neutrality, and we managed to include CGI, the steering committee, as one of the actors that need to be heard in the process of regulating network neutrality. So I think that by doing that, we try to merge the two different tracks that you mentioned. But of course, on the international level, it's maybe more difficult to do that. Because if you look at different international organizations, like WIPO now has a very strong track of intellectual property that is related to the internet treaties, and how we're going to follow up with that. UNESCO has a track of development of cultural and capacity and education online. How are we going to deal with that? So this is kind of split in different organizations. And that's one of the things we discuss when we talk about institutional improvement. How do we become aware of what is taking place in different fora and make sure that these policies are coherent? They look at the internet as a whole, because nowadays it's very easy for actors to have different positions in different fora. And I follow WIPO for a while, and for instance, in some spaces the US is really a freedom fighter, a fighter for access to information and so on, whereas in WIPO, because they have this participation of private sector interests in the delegation, then their positions are much more conservative. But this is not visible to the people that are working with access to information on internet governance. So how do we make sure that we achieve more coherence and these different policy arenas become more visible and trackable for us? This is the challenge.
Thanks very much. Yes, sure, please.
If I may, in another life, I also work for a government, and so I have some understanding of the issues that the governments face in trying to address a problem or address a challenge. The interesting part about policy development at ICANN is I really like to look at it as finding solutions and having people, experts and others, to help you identify those solutions. And so in many ways, the issue, if I understood your question correctly, should you have two systems or whatnot, you're not alone in that. Other people and other groups have to address how best to solve a problem. Is it purely a directive of government? Is it a combination of a light directive and some other cooperation among the actors? And this is where consulting with the stakeholders can provide you a solution that may be something less than a full-blown criminal law approach, if you will. And so this is a way to kind of find those solutions so that when it comes to compliance, there is an understanding of what is expected, and compliance then follows rather regularly because people know what to do and how to approach things. So it's just a possibility of again, thinking differently of how you can engage the stakeholders to help you solve that problem, because governments have important problems as well to address.
Thanks very much. I think we have to come to an end due to the time restrictions. I'm sorry that it has not been more interactive. It's more or less our bus driver's fault. If we had access to the internet and Google Maps or things like that, it could have been more interactive. So you see the internet has a lot of indirect effects in this respect as well. Nevertheless, I can promise that in our efforts, our research efforts and the network of centers, we will consider all the things that you have put on the table here right now. It was extremely interesting. And I just take the privilege of the chair to define the rough consensus that I felt, at least, that is that when we talk about internet issues, the starting point has to be this kind of multi-stakeholder approach we have. On the other hand, I have seen that when we open the scope and when we move from technical issues to non-technical issues and apply this approach, then we have to think harder about some aspects you have mentioned, like openness, like having additional channels for participation, for example, and links to other communities and fields of expertise. And I think that's a lot to think about this day and the conferences to come. So thanks very much to the panelists here, and thanks to you for participating here, and thanks again to the organizers and Laila Keza. Thank you so much. Thank you.
Working paper.
Very good.
Thank you very much again for being with us today. Now, I want to close this session, and as academic community, we have lots of things to do and have to work. Thank you very much.
Thank you for coming along. This is really really interesting in this issue because good, great issue. You see yeah. The problem is it's not quickly governance. I agree. We have a really fundamental discussion strength how to organize. So I'm sure now that we're here, I think we have to distinct. You just have to encourage that.
I actually, it's very good.
how to operate these stakeholders and still have a full parliamentary administration.
So that it doesn't look like an altar here, right?
They only have a hammer. They think they can have stop as opposed to other things.
So, very nice meeting you.
Same here.
Take care.
Yeah, thanks again. The action report would be better.
Yes. Okay. Thank you so much. No, very good. Yes, 3.
Aslında erken de geldi. Sertaç gecikti. Şu kafasına bir olarak kaç işim var. Ondan sonra orada geç kalmış.
Yesterday I vanished.